Welcome to the Deep Dive. Today, we're taking a close look at a single document, peeling back the layers to see what's underneath.
That's right. And the document today is quite something. It's a formal investigative report by Victor Sandy.
It deals with the EPA versus RBC Royal Bank case here in Trinidad and Tobago. And it alleges, well, a pretty significant trail of deception.
A strong phrase, definitely. The report claims there was deliberate manipulation at the heart of this legal matter.
So our mission today is to follow that alleged trail. We'll go step by step through the report, looking at the evidence Sandy presents.
We want to understand how this whole thing, this dispute involving estate constables, could have supposedly gone so off track.
Okay, so the core issue seems to be this list of names, right?
Exactly. The report focuses intensely on a list of 42 estate constables.
Which sounds straightforward, except
the report claims only 14 officers were actually legitimately involved in the dispute that should have gone forward.
14 versus 42. That's a big difference.
It is, and the allegation is that this larger, allegedly falsified list was used in court, potentially misrepresenting the entire case.
Okay, let's trace this back. Where does the report say this trail begins?
It points to an early filing, something supposedly done before March 2014.
And who was involved in that initial step?
Two names come up right away, Harrison Thompson and Robert Rumutar. They're flagged as key figures early on.
So what did they allegedly file?
The report suggests they submitted this list, the one with 42 names, to the Ministry of Labor sometime before March 7th, 2014.
Okay, filed it with the ministry, standard procedure.
Well, here's the first sort of snag, according to the report. This filing was apparently not registered for conciliation.
Not registered. What does that mean in practice?
It means it didn't officially enter the process. The report raises possibilities. Maybe the ministry rejected it, or perhaps it was deliberately held back.
So it's a bit murky right from the start. An attempt was made, but it didn't quite stick officially?
Precisely. It creates this air of mystery around that first action with the 42 names.
Then the timeline moves to May 2014, and this is where the report's author, Victor Sandy, personally gets involved.
Yes, he visits the ministry himself to check on the status of the conciliation for these officers.
And what does he find?
He finds that the file hadn't been acted upon yet. It was just sitting there.
So, months later, still nothing.
Correct. A ministry employee apparently acknowledged this, said sorry, and promised to get a conciliation date assigned.
But here's where it gets really interesting, isn't it? The report mentions another filing around the same time.
Yes, and this is crucial. It mentions a 7 May 2014 EPA internal referral. And this referral involved the 14 officers.
The ones who were, according to the report, the legitimate parties to the dispute?
Exactly. The ones who were actually part of it, contributed to the funds, everything.
And what happened to that filing? The one with the correct 14 names?
Here's the kicker. According to Sandy's report, it never appeared in any court filings. It seems that way. It's like the legitimate track just disappears from the official record presented later on.
So we have the unregistered 42-name attempt early on, then a legitimate 14-name referral in May that goes nowhere visible, and the file is still inactive at the ministry. What happens next?
The report identifies September 2014 as the real turning point. It seems that's when the ministry finally moved.
And which version did they move on?
This is key to the alleged deception. The report states the 42-name version, the one that wasn't registered back in March, was mistakenly or deliberately activated.
Mistakenly or deliberately. Big difference there.
Huge. But the result, according to the report, was the creation of a bogus to September 2014 referral date.
A bogus date. Why bogus?
Because it seems to stem from activating the wrong file, the one that wasn't properly registered or perhaps even legitimate in the first place, months after the actual legitimate referral happened.
And did this September 2nd date stay internal to the ministry?
No, absolutely not. The report traces it directly into significant legal documents.
Like what?
Like Clay Hackett's affidavit, a sworn statement meant to be factual evidence in court.
Wow. So it's presented as fact under oath.
Allegedly.
Yeah.
And it also appears in the judicial review filings, the documents used to challenge the ministry's or tribunal's decisions in higher courts.
So this date gets cemented into the formal legal narrative.
It does. And the report stresses the legal significance of this specific date.
Which is?
It apparently placed the certificate of unresolved dispute outside the lawful 14-day window under Section 59 of the IRA.
Okay, unpack that a bit. The IRA is the Industrial Relations Act.
Correct. And Section 59, according to the report's interpretation, sets a strict 14-day deadline for certain steps after a dispute is reported to the ministry.
So by using this allegedly false September date,
They miss the deadline. The report argues this potentially invalidates the whole conciliation process, or at least makes it legally questionable.
if someone had challenged it based on that technicality.
Exactly. The report suggests it could have been grounds to throw the whole thing out, potentially derailing the legitimate claim of the 14 officers if this flawed process was the one moving forward.
Which leads to the question, where did this 42 name list, the one that seemingly caused all this trouble, actually come from?
The report zooms in on Robert Ramutar as the likely original source.
Okay, and what's the evidence presented for that claim?
Several things. First, Ramutar himself was one of the officers retrenched by the bank, so he was directly involved.
He had a personal stake.
Absolutely. Second, his name is listed right at the top of the 42 name filing. It's styled as Ramutar and 41 others.
So he's the lead claimant on that specific list.
Yes. The report also states he was involved in choosing who gave witness statements later on, and he even testified himself in the tribunal hearings associated with this 42 name track.
And how might he have gotten all those extra names? The ones beyond the 14?
The report suggests he had access to retrenchment letters, officer lists, potentially from bank contacts or EPA records. It hints at possible unauthorized access or misuse of data.
That's a serious implication. And the motive. Why allegedly provide this inflated list to Harris and Thompson?
The report speculates on a few reasons. One, inflate standing. Make the case seem much bigger, involving more people than it really did.
Strength in numbers, even if the numbers aren't quite right?
Sort of. Two, maybe to avoid admitting delay. Remember that initial filing wasn't registered. Using the 42 names later might have been a way to paper over that earlier snag.
Keep the ball rolling, pretend it was all smooth.
And third, just to pad the file. Make it look more substantial for the ministry, for the Industrial Court Tribunal.
Okay, so Ramutar is pinpointed as the source, allegedly motivated by inflating the case and covering delays. Then the report brings up file numbers, ST617 and ST2217. What's going on there?
Yeah, this adds another layer. The report clearly states that ST617 is the file number associated with the fabricated 42 name filing.
That's the one that appears in the official court records.
Yes, that's the number consistently referenced in state documents, court filings related to this whole saga.
And ST2217, what's that?
That one's more mysterious. The report calls it a possible real second hearing, maybe linked to the actual 14 officers.
What?
But, crucially, it does not appear in the public domain. The report suggests it might have been deliberately buried.
Buried. That implies someone actively suppressed it.
That's the implication. The theory presented is that ST2217 might represent the true dispute, the one with the 14 officers.
Well, ST615, the one everyone saw,
was used to launder the falsified version of events into the official record, basically substituting the inflated, problematic version for the real one.
So the public and judicial record reflects ST615 built on the 42 names and the questionable date, while the potentially legitimate ST2217 is nowhere to be found.
That's the picture the report paints, a manipulation of the actual case files.
If all this is accurate, the legal fallout would be immense. The report lists specific alleged violations. Let's go through them. First, misrepresentation to court.
Straightforwardly, the report argues this happened by using that false list of 42 names and the bogus September 2nd registration date in court documents, presenting an inaccurate picture of the dispute.
Okay. Second, abuse of process.
Here, the argument is that filing for judicial review and any subsequent appeals based on this allegedly flawed foundation, the wrong names, the wrong date, constitutes an abuse of the court's process itself. Building a legal challenge on shaky ground, essentially.
Then there's violation of Section 4A. Sounds constitutional. What right is that about?
Likely relates to fundamental rights. The report frames it as misuse of petitioner's identity and property name.
Meaning using people's names without their permission.
Exactly. Including officers in that 42 name list without their consent, using their identity in a legal case they weren't actually formally part of.
Okay. And violation of Section 4B.
This likely concerns the right to access the courts. The report claims this right was denied to the legitimate 14 officers. Because their actual dispute, potentially represented by that elusive ST2217 file, was allegedly sidelined or obscured by the 42 name filing, ST615, they were denied their proper day in court on their terms.
And the last one listed is very serious. Fraud upon the court.
Extremely serious. The report alleges this occurred because the state filings themselves were based on including officers who hadn't consented, Presenting a case built on this non-consensual foundation, potentially hiding the real dispute, is argued to be a fraud against the court system's integrity.
These are heavy allegations. Unsurprisingly, the report doesn't just stop there. It makes recommendations.
Yes, it calls for concrete actions based on its findings.
What kind of actions?
First, an immediate referral to the Commissioner of Police and Fraud Squad. They want a criminal investigation.
Makes sense given the fraud allegations. What else?
Filing disciplinary complaints with the Law Association about the lawyer involved with the affidavit containing the allegedly false date, questioning the professional conduct.
Accountability for the legal professionals involved.
Right. Also, adding supplementary constitutional relief to existing legal actions, basically asking the court to address these alleged rights violations.
One more.
A call for a public inquiry, specifically into how state attorneys ended up using this 42-name list, apparently without verifying who consented or checking its authenticity against, say, the ministry's own records or the earlier 14-name referral.
So, looking at potential systemic failures or lack of due diligence within government legal departments, too.
That seems to be the thrust of that recommendation, asking how this could have happened on the state side.
The report then wraps up with a strong concluding statement. How does Victor Sandy summarize his findings?
He really hammers home the core point. The 42-name filing was, in his analysis, unauthorized, inaccurate, and critically, it was used as the procedural basis for dismissing a lawful dispute.
And delaying justice.
Yes, delaying justice for the actual claimants for over a decade. He points again to what he calls coordinated misrepresentation by Ramutar and Thompson.
And implicates others.
It suggests a failure of due diligence, at minimum, by state actors who used the list without, it seems, adequate checks.
So we've followed this alleged trail laid out in the report, from that early unregistered filing.
Through the substituted names, the bogus date appearing in sworn affidavits.
The alleged role of Ramutar, the mystery of the two file numbers.
The serious legal and constitutional violations claimed. And finally, the calls for investigation and inquiry.
It paints a picture, as alleged in this report, of a justice system pathway potentially distorted by misinformation.
It absolutely does. And reading through Sandy's step-by-step account, you see how one alleged discrepancy, that list of names, could potentially ripple outwards with huge consequences.
It really underscores how crucial accuracy and verification are, especially when dealing with formal legal processes and people's rights.
No question, the integrity of the entire system relies on the foundation being solid.
Which brings us to the final thought for you, our listeners. After hearing the details outlined in this specific report, this alleged trail of deception, what does it make you think about the trust we place in official records and legal proceedings?
Yeah, when a report like this suggests that the very foundation of a case could be manipulated, how does that affect your confidence in the system's ability to find the truth and deliver justice?
It's a significant question, one that goes well beyond this particular case in Trinidad and Tobago. Something to reflect on.
Definitely food for thought about transparency, accountability, and the checks and balances we rely on.